Citizens of the gallery, sometimes the most dangerous evidence in a case is the evidence no one can see. A deleted message, a missing recording, a destroyed document. When the court concludes that evidence vanished improperly, it may permit a devastating conclusion. The missing proof would have harmed the very person who destroyed it. This principle is called adverse inference. This is how absence of evidence itself can become evidence. I am Polemopicus, and this is Polemopicus Legal. Legal concepts explained for non-lawyers, by a non-lawyer for educational commentary, and is not legal advice.
In court, evidence matters. Whether documents, emails, texts, photographs, records, or video footage. The legal system depends on evidence to reconstruct what happened. But what happens when evidence disappears? What happens when a phone is wiped, or a surveillance recording vanishes, or important messages are deleted after litigation becomes foreseeable? The legal system does not always treat that absence as neutral. In some situations, the court may allow the jury to conclude that the missing evidence would have been unfavorable to the party responsible for its destruction. That concept is called adverse inference, and in many cases, it can dramatically alter the outcome of litigation. An adverse inference is a legal conclusion, or permitted conclusion, that missing evidence would likely have damaged the position of the party responsible for its disappearance. In plain language, it works like this. If a party destroys or fails to preserve important evidence, the court may allow the fact finder to infer that evidence probably would not have helped them. This is important because courts recognize a basic human reality. People generally preserve evidence that supports them. Suspicion naturally arises when relevant evidence disappears under questionable circumstances. Adverse inference exists to protect fairness. Without consequences for destroying evidence, parties could erase damaging material, important records could disappear strategically, litigation would reward concealment, and courts would struggle to determine truth. The doctrine therefore serves two purposes. First, it discourages destruction of evidence. Second, it helps restore fairness when evidence can no longer be examined. Because once evidence is gone, the opposing side may never be able to recover what was lost. Adverse inference is closely connected to another concept, spoliation. Spoliation refers to destruction, alteration, loss, or failure to preserve relevant evidence. When courts find spoliation occurred, they must decide what remedy is appropriate. One possible remedy is adverse inference, but not every missing file automatically results in that outcome. Courts examine timing, intent, prejudice, and preservation obligations. One of the most important questions is, did a duty to preserve exist? This duty generally arises when litigation is pending, threatened, or reasonably foreseeable. Once that duty exists, parties may be expected to preserve communications, stop routine deletion, secure devices, maintain records, preserve electronically stored information. This is critical. Deleting records before litigation is foreseeable may be treated very differently than deleting them afterward. Timing matters enormously. Courts distinguish sharply between intentional destruction and accidental loss. Intentional destruction examples: deleting texts after receiving legal notice, wiping devices, shredding documents, removing metadata, deleting surveillance footage intentionally. Intentional conduct creates strong suspicion. Courts are much more likely to permit adverse inference in these situations. Negligent loss. Sometimes evidence disappears through carelessness, poor data management, automatic deletion systems, technical failures. Courts may still impose remedies, but severe adverse inference instructions are often more closely tied to intentional conduct. The level of culpability matters. Modern adverse inference disputes frequently involve digital evidence. Examples include emails, text messages, cloud storage, internal chat systems, social media content, metadata, or surveillance recordings. Digital evidence creates major preservation challenges because it is easy to delete. Systems auto-overwrite information, Devices sync across platforms. Records may exist in fragmented locations. Modern litigation increasingly revolves around electronic preservation obligations. Courts often examine several factors before allowing adverse inference. Was the evidence relevant? The missing material must matter to the dispute. Did a preservation duty exist? If litigation was foreseeable, obligations increase significantly. Was the destruction intentional? Intent strongly influences the severity of sanctions. Was the opposing party harmed? Courts evaluate whether the loss impaired the ability to litigate fairly. Are lesser remedies sufficient? Adverse inference is powerful, so courts sometimes consider alternatives first. Adverse inference can appear in different forms. Sometimes attorneys are simply allowed to argue. The missing evidence likely would not have helped them. Other times, the judge gives a formal instruction to the jury. The instruction may explain that jurors are permitted to consider the destruction of evidence when evaluating the facts. The exact wording matters. A permissive inference allows jurors to decide whether to draw the conclusion. A mandatory inference is far more severe and less common. Adverse inference can damage a case dramatically, not because the missing evidence is seen directly, but because the destruction itself affects credibility. Jurors begin asking, why was the evidence deleted? Why did it disappear? What would it have shown? Why wasn't it preserved? In some cases, the destruction becomes more harmful than the underlying evidence ever would have been. Missing evidence automatically proves guilt. No. Adverse inference permits a conclusion. It does not automatically decide the case. Every deleted message creates sanctions. Not necessarily. Courts evaluate relevance, intent, timing, and preservation duties. Only intentional destruction matters. No. Negligent preservation failures can still create serious problems. Deleting evidence before a lawsuit is always safe. Not always. If litigation was reasonably foreseeable, preservation duties may already exist. Adverse inference is powerful. Courts, therefore, use it cautiously. Judges understand that data systems fail, files are lost, devices malfunction, preservation can become technically complex. The goal is fairness and not automatic punishment. Courts try to balance accountability, prejudice, and proportionality. Adverse inference reflects a deeper principle of the legal system. Parties should not gain advantage from the disappearance of relevant evidence. The legal system depends on preservation of proof. Without that expectation, litigation could become a contest of deletion rather than a search for facts. Evidence matters. But so does the disappearance of evidence. Adverse inference is the doctrine that allows courts and juries to consider whether missing evidence would have harmed the party responsible for its loss. It recognizes a simple reality. When relevant proof vanishes under suspicious or avoidable circumstances, the absence itself may become part of the evidence. And sometimes, what is missing speaks louder than what remains.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.